Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now, it's always a privilege for me to review some of the most important practitioner books that we have. I'm not talking now about the practice books so much as the main substantive law books which the Sweeton Maxwell Common Law Library produce. Now, my favourites, of course, are Chitty on Contracts and a whole range of other books, but one that I do like reviewing, which is the thorny subject of what we've always known as pleadings, whatever you want to call them. And the book that I'm going to review is in 2 volumes. We've reviewed it before. It's a first-class work, and it's something that every firm and every barrister's chambers should have. It's Bullen and Leake and Jacobs' Precedents of Pleadings. It's now in a new 18th edition as at the end of 2015. The general editors are Mr Justice Blair, Lord Brennan, Queen's Counsel, Professor Sir Robin Jacob and Mr Justice Langstaff, and there are specialist contributors. It's in 2 volumes, as I say, and it's part of the Sweeton Maxwell Thomson Reuters Common Law Library. And my wife Elizabeth and I have looked at this book. We had a long chat about it because we're both very well aware of it, and we gave a title for our review, which is on the web and in the journals: Confounded by CMCs? Read the definitive work on pleadings, now in a new 18th edition. And I'm going to call them pleadings. I know that we've got different words again and everything else, but I'm not too fussed. That's what I call them, and that's what they're going to be. This is the spine. There's the front, and then there's the spine. There's nothing on the back. The first volume is heavy, of course. It runs to a large number of pages, about 1,000. There is the, you see the very detailed index at the back. I can only give you a superficial view, really, of these books, but you get an idea. I'm sure you've seen them before, but if you haven't seen the books, and if you're relatively new to the legal profession, I think you'll find it quite helpful. That is volume 1, the front page. And then after that, you go in to a list of all the people who've been contributing and the various areas where they've covered. See a lot of people there. I can't mention them all by name, unfortunately, but you can see a large number of people have been involved in all of this. There we go again. And then there's a forward to an earlier edition as well from Lord Wolfe. And then there's a publisher's note about the current edition, which is worth reading. It just says it's really a thank you to all the people, and then you've got various other ones running through. Then we get into the, I'm not going to bother with all of the earlier stuff. What we then get into is the book itself. And like everything else, it's quite important to get an idea of how it's organised. Now, the table of contents are structured like that. So it's at page 23, right at the beginning. Then you've got, that's for volume 1. Then volume 2 is also included, so you can see at a quick view where things are. And then that's the end of volume 2. Then the case law itself, of which there's a large amount. Then you've got after that the statutes, of course. You see how we're getting into the book very quickly because of a huge amount of statutes. EC legislation also included, foreign legislation. Then we get table of international conventions. Then we get section 1. You see how far into the book it is already. There we go, right at the beginning, introduction, which is, it says, each system of law requires a method of defining the dispute that is to be decided by the court. In the English common law tradition, this role is played by pleadings. This is a generic term to describe the formalised process by which each party states its case prior to trial. And that's what we do today, although it's getting even more complex with things like protocols. Now you can see immediately that there are footnotes at the bottom. There's a lot of detail. What I do like about each of the sections is you do have a short index at the top, which tells you where things are. And of course, what you have with this structure is you have the paragraph numbering at that side. It's on the left as I'm looking at you, and on the right as you're looking at it. And of course, you've got again the footnotes there. And then you run through all the way through. A huge amount of detail, a great deal of assistance for anything you're particularly looking at. That's volume 1, and volume 2 is just continuing. There it is again, that's volume 2, and then you've got a repeat of the table of contents and everything. You've got a repeat of cases and statutes. In fact, it's the tables mainly of cases which you've got here. You do have the tables of statutes as well, then the EC, and then all the other stuff, and then you get to the next page, which is section O. So we've got the first part, it's equitable remedies, and you go launch straight away into an introduction, section 50 there, and then you've got after that section 51 deals with injunctions. And then of course it runs all the way through exactly the same. You've got a lot of examples of the forms and all the other structures for precedent, these particulars of claim, and then right at the back again you've got the detailed index. So that is the book, and it's, as I say, it's a heavy book. The second volume is probably about the same length of about 1,000, in fact just over. So volume 2 is slightly bigger, not very much, but slightly bigger. So, and of course you've got ready access. Now what do we say about it? Because this is a charming book. All the common law library books are absolutely first class. That's where you find the law. No question about it in my view. This is where you get all of the information you need, and you've got to know your way around these books depending on the sort of work you do. But you certainly should be aware of them, and most chambers certainly will have copies, and you will find quite a lot of public libraries have these books too, because they are actually where the law is contained, outside things like Hallsbury. So this is what we say anyway. If you're ever tempted to refer to Bullen and Leake and Jacobs' precedent of pleadings, I'll get it right, as the grand old man of legal reference works, you'll need to be reminded that from 1860 to the present, it has remained forever young, because like much of the stuff in the Common Law Library, it's got a history to it, and it goes back a long way, in this case to Victorian times. If you look at its publishing history then, it's gone through frequent updates across almost 2 centuries. And since 2001, a new edition has emerged approximately every 4 years with regular supplements. That's something I should say with all of the common law titles. You get the supplements, and they do appear 4 to 5 year intervals as the statutes and the cases change and so forth. And a good update quite often is needed because of such substantial changes that have taken place. So this year, this is the end of 2015, the publishers, who are Sweet Maxwell, Thomson Reuters, have brought out a new edition for their common law library, and it's the 18th edition, this one. Ever scholarly, ever reliable, and ever eminently readable, and that's the point about all of them, they are very easy to read, and bang up to date. It contains updated commentary and statements of case in line with the traditions of its distinguished predecessors. And Lord Wolfe's comments on the 14th edition in 2001 still hold true, we think, for the 18th edition. This work, he says, is an indispensable guide for those engaged in the art of litigation, adding that those using it will have no need to fear case management conferences and a managerial judge. And the book is falling down even now. I'll just put it back up again and make it, there you go. Obviously didn't like what I was saying there. And I'll just repeat that. I have no fear, apart from the book falling down, of case management conferences and the managerial judge. In other words, it's like everything as a barrister, certainly as a solicitor, make sure you've prepared yourself properly and you've covered as many of the possible difficulties that might crop up. So for a clear explanation, for instance, of the role played by pleadings, the introduction is well worth reading. Following a necessary change in nomenclature occasioned by the Civil Procedure Rules in 1998, the CPR, they are now termed statement of case, although the term pleadings still remains in current usage. And I said earlier, and I'm afraid I do tend to use pleadings because that's what I'm used to. And I suspect we're going to have pleadings as as the actual terminology. I mean, you basically have to change the title of the book. However, I can't really see it being precedence of statement of case. It may be that they change that, but we'll see. I think pleadings is where we're reasonably in a good place on that at the moment, and I think it'd probably be a good idea if we kept that without being too controversial. Here then, in the two hefty volumes, both of which are probably strongly anchored now there, and they'll fall off, over 1,000 pages each, you've got placed before you the informed, it's doing it again, the informed, I'm going to put it up like that this time because it's going to fall down otherwise. There we go. What you've got here in the two hefty volumes, and they are hefty, you've got the informed and insightful commentary of 70 practitioners, mainly barristers, all noted for their expertise in their respective specialties, which range from arbitration and banking and financial services through to IP, PI and sport. And in fact, they're all listed in the index at the front, depending on what you're looking for. Collectively, these specialist contributors seem to be on a commendable mission, not just to explain, but to clarify, much to the relief, no doubt, of lawyers almost everywhere, be they barristers or solicitors, who from time to time find themselves dazed, confused and befuddled by what often emerges as a tangled web of litigation. And frankly, it can be very confusing, as I'm sure we all know from time to time. So as far as possible, the book, in its two volumes, quite successfully provides answers to any number of legal issues, debates, conundrums and so forth, to which there may be several answers or no unequivocal answer at all. An interesting example out of hundreds and hundreds is the highly topical section on human rights and references to the European Court of Justice. And I think probably that's well worth looking at because it's so contemporary. There's a quote here: "The bill that was ultimately presented to Parliament," the section explains, "has been universally recognised as a very subtle piece of drafting, which retains parliamentary sovereignty but combines it with a very strong requirement on courts, tribunals and other public authorities to act compatibly with key convention rights." Now that's a quote that's quite important. Whether it will haunt Michael Gove and the current Conservative government, I don't know. But you can see here that there is a strong word there. It says, apart from acting compatibly, it says it's basically a requirement to act. But it doesn't actually go any further in terms of whether it's mandatory or whether it's persuasive, and that's really where the issue has been, because it says it retains parliamentary sovereignty but combines a strong requirement. That's really where the issue is, about how far do you go. So you can see that argument is developed, and that will be for the next issue. That'll be the 19th issue. Eventually there will be obviously further commentary, but that's a long way down the line. Let me go on from there. Considering the wealth of material it contains, it's fortunate that this two-work volume is easily navigable thanks to the detailed table of contents, which is available in both volumes, I hasten to add, and a lengthy and minutely detailed index of over 70 pages, again in both volumes. Also, there are over 200 tables of cases of, and here's the list, case before the ECJ, the CFI, the European Court of Human Rights and so forth. Then there are statutes, statutory instruments, EC legislation, foreign legislation, international conventions and so on. And you've got them all at the front of both of the volumes, depending on what you're looking for. I've found it quite easy to hunt things up. It's not a difficult task to do that. It's a treasure trove of reference sources as well as informed analysis and commentary. And the latest edition of Bullen and Leek and Jacobs from the Common Law Library is, we think, invaluable for barristers and solicitors, because they will provide the client with the highest quality of assistance and advice, and it's a great investment. The law is generally stated as at the 31st of October 2015, and the publication date is actually cited at 2016. Obviously there will be additional supplementary volumes to go with these two volumes in due course, as and when changes come. Let's just have a quick last look. There's volume 1 there, and I'm not going to drop it this time. There's the spine, just opening it in the middle. Sale of goods, you can see here a huge sale of goods, section 25, the precedents, and a huge index right at the beginning. Normally it's a relatively small index, but you can see the first index, the index for this section is very long. Then we get into the actual legislation itself, the paragraph numbering there, as I say, and then you get, again here on sale of goods, you've got some very useful defences, denials of sufficiency, all the usual stuff, and it gives you the statement of truth is just in brackets at the end, just to remind you to put it in. It's amazing what you can forget when you're drafting, so this does help. Let's go over to another one. Private law, High Court claims, for instance, there's another area there. And then section 46, that deals with environmental claims. You see how it's structured there. It's got a part number and then the title. And you need to go to the index at the beginning, the contents, let me rephrase that, at the beginning, which will then set you out on where to find it. So you've got, if you look at the contents, you've got the letter A and then running through. That's how you can find stuff, and I hope that's of some assistance. I would like to thank, this is by the way exactly the same thing for volume 2. Now I would like to thank everybody very much indeed for the huge amount of effort that has gone into producing these 2 volumes. I appreciate how much work has been done, and we cannot do our jobs as lawyers without having this sort of information readily available. It's expensive, the book, but it's something we must have. So can I thank everybody on behalf of the profession. We're very grateful for all this information that's come together in one place. It's very difficult to understand some of it sometimes, but at least we've got it there. So thank you to all concerned. And we'll look forward to the next volume in due course. Good luck. Bye-bye.